This is a conversation, so I have slides and I can talk for 15 minutes, but you can feel free to interrupt and sidetrack as much as you would like. My name is Shuchart. I'm Senior Director for Legal Strategy at Kids in Need of Defense, which is the leading national nonprofit that works with unaccompanied migrant children. And the conference is about class actions and money and ethics, and most of what I'll talk about does not really have the money component. But I was hoping to talk about, have a conversation about how class actions have been playing out in administrative litigation around changing national immigration policy, and again, largely from the perspective of the unaccompanied children we work with. Okay, thank you. Largely from the perspective of the unaccompanied children we work with, but also if this is an area of the news that you pay attention to in the last couple of years, you may have noticed there's been a lot of immigration policy news, and a lot of it driven by litigation in the courts. Can I get a show of hands with who in the room is an attorney, just so I pitch things in the right way? Okay, that's helpful. Thank you. So this is a little description of KIND, and we'll have our URL up at the end, but it's supportkind.org. Our headquarters is in DC, but we have about 14 field offices around the country, including a big one here in New York, and operations now in Europe and Mexico, and some small operations in Central America. Who are unaccompanied children in the sense that it's used in immigration law are children who arrive in the United States or are found by the federal government in the United States without immigration status and without a parent or legal guardian available to provide care and custody. And factually speaking, a lot of children come with a non-parent relative, and under the law they are treated as unaccompanied, though they may ultimately be reunified with a grandparent or an aunt or someone or another sibling who they come with. And the critical age is 18. So, if we meet with a family that's a 19-year-old sibling who came with a 12-year-old sibling, that's not, in the eyes of the law, that's not a family. That's a single adult and an unaccompanied child, because one's over 18 and one's... What are the ways that our work intersect with class actions? This is really just kind of like an outline of the talk. The first and the big are national immigration policies. Always litigated on a class basis. Sometimes an institutional plaintiff, a legal services organization that works with immigrants will be the lead plaintiff. But often, for standing purposes, you're really looking at a 2C or 2B class action of all the affected people. So here are just a couple of examples that have been very impactful to clients of ours in the last couple of years. Vangala, which is not a case we were involved in, but it was a case that moved very quickly. The Trump administration had imposed a policy called the blank spaces policy that on certain immigration forms, and the intent was clearly to roll it out to all of the immigration forms, the form would be rejected if any space was left blank, even if it was not applicable. So if your brother had no middle initial and you left the brother's middle initial space blank rather than writing NA, the form would be rejected, and you would lose your place in line, and you'd have to refile, and so on down the road. If we're filing for a 5-year-old, and there's a section where you list children, if you left that blank, the form would be rejected. You have to put NA for whether the 5-year-old has a child. So at the tail end of the Trump administration, like in December of 2020, they folded on that. I think it was Christmas Eve of 2020, and agreed to rescind the policy and to nunc-pro-tunc reevaluate all the forms that had been rejected during that time. The settlement statement by the plaintiff said they think there were 60,000 people affected by that. Pointless policy, introduced a bunch of delay, the government defended it for a couple of years, and then the class action was able to resolve it fairly quickly. Another very large case, I think hundreds of thousands is my estimate, but there's a rule if you are apprehended at the border or if you come into the country, really, you only have 1 year from entry to apply for asylum. That's told if you're a child. And there's an obligation, if you're arrested near the border or processed at the border, to be told that you only have 1 year to apply for asylum. Well, they were systematically not doing that for many years. So there's now a class settlement. It's an opt-in, but there's a class settlement for folks who missed the 1 year filing deadline because they didn't receive actual notice to have another opportunity to apply. That's the Mendez-Rojas case. Now, there are a lot of national policies, like I was saying, that are challenged, not necessarily on a class basis. Asylum Works is the most recent one where we won. And this was a case where it was a regulatory change. It was a notice and comment rulemaking regulatory change that made it much harder for people who were applying for asylum to receive work authorization. It can take years to go through the asylum system. And during that time, people need to support themselves. And Congress allows for work authorization. But the Trump administration changed a couple of regulations to make that much more difficult. The problem was that when they issued that regulation, it was when a guy was claiming to be the acting Secretary of Homeland Security, a guy named Chad Wolf, who was never validly appointed, partly because he was put there by the prior acting Secretary of Homeland Security, who had also never been validly appointed. And the amazing thing about this case is there are about 7 different class actions or impact cases for about 7 different DHS regulations the last 2 years of the Trump administration, all of which came out the same way, that this guy was never legally acting as the Secretary of Homeland Security, so the regulation wasn't validly enacted. And the government just kept defending it right up into the Biden administration. We won this case about 70 days ago. That for the same reason every other court had said this guy was never validly signing regulations for DHS, he didn't sign this one validly. And that's one that wasn't a class action. Like I say, we had individual plaintiffs, about 18 different individual plaintiffs representing different, they were sort of people who would have been your class reps if we'd had to run it as a class action, people who typified all the different harms, and then a couple of institutional plaintiffs. There are some that we've run that are state-specific. In particular, the children we work with, in addition to asylum, the principal form of immigration relief that's available to them is something called special immigrant juvenile status, which requires that a state court find, either before the age of 18 or 21, that the child needs to be put in, something like a state custody award. And the Trump administration had changed the policy in a way that misread the ability of kids between the ages of 18 and 21 to qualify for that status under the law of several states. So there were, 5 or 6 class actions in all those affected states, and the federal government lost all of them or settled all of them. But that was a state-by-state class action effort. And then there are a variety of other cases where they're not 60,000, hundreds of thousands of people who are affected, but there are a few hundred or a few thousand that are still litigated on a class basis. I think the one that's most famous in here, the one in the middle, is Ms. L, which was the big family separation class action brought by the ACLU in the Southern District of California in the spring of 2018. If you remember the family separation story being very big in the news at that time, it sort of peaked when that court issued an injunction halting the separations, and then ultimately that court's been supervising a lot of the reunification work that we've been involved in. And there's a spin-off from that, by the way, that is more like a mass tort thing, working on whether there's an ability to get the families monetary compensation for what they suffered. But you can't do Federal Tort Claims Act cases as a class action. So while there's some national orchestration of those cases, in theory, if the government doesn't ante up and settle them, it's thousands of individual damages cases that may be managed in some kind of joint way. The top case there is the one that I spend a lot of my time on, JOP, which is another class action against a particular policy that affects a few thousand kids who are seeking asylum. And then there's this one really extraordinary case in this area that's interesting to think about. Does anybody notice anything strange about that docket number? What if I told you this is a case where something hits the docket 2 or 3 times a week? It's a 1985 case number, and the defendant on the top of the docket sheet is Ed Meese, who stopped being Attorney General in like 1985. 1986. This case was settled in the late 90s with a settlement agreement that said this settlement will sunset once the government issues regulations on this topic. Now, in the Trump administration, they did issue some regulations, and they moved to terminate the consent decree. And the judge who's overseeing this rejected it because the settlement agreement said that the terms of the regulation would have to be consistent with the agreement. But of course, the Trump administration tried to override certain provisions of the agreement and change it materially. So the consent decree is still in place from a case that started. The consent decree is signed when it's Flores v. Reno in, I think, 97. So the case is only 12 years old at that point. But it's still ongoing. There's still special masters filing regular reports. And it's done an enormous amount of good for the unaccompanied children we work with, making sure that there are enforceable standards and judicial oversight. But kind of the way some school and prison systems in the 70s and 80s before some reform movements were under judicial supervision for a long time. Some of the children's immigration custody system has been under the supervision of this class action for a very long time. So a lot of attorneys in the room. I have to make a little pitch. Our primary model, we're the largest nonprofit that serves unaccompanied children, is through leveraging pro bonos. We do training, we do mentoring, we do intake and find cases and place them with attorneys in firms and in-house all over the country. We've referred 20,000 children in the 14 years we've been around, and there's still an enormous need. 60% of kids, when they go before a judge, an immigration judge, do not have representation. It's publicly funded to a degree, but there's not funding for nearly the level of legal representation that's needed. So if you or your firm or your organization would like to get involved, that's our website. We have, like I say, we have an office here. We have an office in Newark. Where else are people from here? California, Texas. We're starting one in Florida, DC, Baltimore. Does anybody have any questions about any of this or anything related to this area? I mean, I really appreciate your time and listening, and if one person gets involved, that would be fantastic, but I'm around if anybody has questions. Thanks.